Filter legal warriors. In this video, I'm going to cover immediate actions you need to take if you or someone you know is served with a restraining order in Washington state. They're called protection orders legally, but we all call them restraining orders. And there's immediate things you have to do because time is short and this is often not a fair fight. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm is defending people charged with crimes all throughout Washington state for more than 20 years. We're putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. You just heard me say we've been defending people charged with crimes. We also handle restraining orders. And you heard me in the intro say it. They're called protection orders under RCW 7.105. And they're one of the most confusing areas of the law and one of the most serious areas of the law for anyone to be involved with when you've done nothing wrong, right? This does not involve the police. It's not the government against you. It's some person out there in the world who doesn't like something you've done, doesn't like something you've said, or just doesn't like you. And they go to the court and they get an order that limits your freedom without you ever knowing about it. They petition for a protection order, a restraining order, and the next thing you know, you get a knock on the door and an officer goes, "Here," and you get this document. And hopefully you get all the documents, but often you don't. And so if you get these documents that restrain your freedom, there's stuff you need to do immediately. I wasn't exactly sure how to title this video because there's things you need to immediately do, and there's some pitfalls you need to watch out for because I deal with at least 40 or 50 calls on this subject a month already. So what's been coming up lately is that you get served with only the temporary order. So you're going to get served with this paperwork, and immediately you need to look at the paperwork and you need to say, hey, the temporary order says I've got a court date on a certain date and a certain time where I have a chance to respond. So I want you to immediately look at your paperwork. That's the action. And see if you see when that court date is, and let's get ready to deal with it. But then also see if you have a petition. That's been missing a lot lately. These police officers are not serving people with petitions. And I think that might be due to reissuances. There's some holes in the system, and the system doesn't know about it because they don't represent clients. I know about it because this is happening a lot. So you have to be served with the temporary order that says how you're restricted, and you also have to be served with the petition, which is the claims that the petitioner filed against you that gave the court a reason to issue a temporary order against you with a date in the future. If you don't have those claims, then there's no way you can respond to the claims because you don't know what they are, right? And you have no reason to know that's even missing. If the officer gives you the paperwork, you assume you have everything, right? And some people will go to court and say, yes, I've been served, and the whole hearing happens, and you've never even had the petition. You couldn't even defend yourself if you wanted to. So look and see if when the court date is, but more importantly, do you have the temporary order and the petition? If you don't have the petition, you have some decisions to make. You're supposed to be served with both documents at least 5 court days ahead of time. That's basically a week, 7 days. There's a court holiday, it could be 8 days. If you're not served with both documents ahead of time, you are entitled to a continuance when you go to court by court rule. But you've got to speak up for yourself. You've got to say, hey, I didn't get served with the petition, so I'm going to need a continuance so I can be served with the petition, right? What you need to do is contact an attorney, of course, but if you're in that situation, you can also choose, if you want, to try to go to the court to get the petition. But remember, that might not be a great strategy because you may need more time to respond. So you should contact an attorney because these things are very nuanced. This law, RCW 7105, is terribly and horribly and utterly against the respondent, the person being restrained. The legislature, you should be ashamed. This is the worst law I've seen, and I've been around 30 years. You're making assumptions that the petitioner is right just because they say so. And let me tell you, these things are used as weapons. And yeah, there's times when the petitioner is right, but you've set up a statute and a system that is unfair, and the judges are unable to hold the line on this because of the instructions to them, because of how many people are filing these things. And as you can tell, I'm not happy about it. So take a look at the documents, see when the court is, and see if you got served with both documents. If you haven't been served with both, definitely be contacting an attorney so you can figure out what the right strategy might be. So what's the second action you need to immediately take? You need to start preparing your response, right? You have to know how this works. You don't generally go to court and testify like you would at a traffic ticket hearing. And you don't testify like you would at a criminal trial. These things are typically done on written statement, not even a sworn statement. Evidence rules don't even apply in these darn hearings, okay? So you need to start to prepare your reply. Now, you've seen some other videos I have on this station. Pick them up, take a look. There's a once upon a time statement that I might suggest someone write out so you get the basics down to yourself about what the story is, because the court's going to decide on emotion. You need to start preparing your response. And you need to find the right forms. You can go to the Washington Court's website to download forms, because these things all have to be written out, filed ahead of time, served on the other side, the petitioner, and you got almost no time to do it. You're living your life. You might have got thrown out of your house. So, you want to contact an attorney, but start preparing your response. The other immediate action, start asking others to help you, right? You got a wife or a spouse who knows something about this? Do you have a buddy? Do you have a coworker? Do you have a witness who can also provide a credible statement, a family member? Those things carry weight, and they're not going to be allowed to testify at a hearing. It's got to be in writing. The court does not have time to let people testify at a hearing. There's some exceptions. Each court does it on their own, but I do this all over the state. I've yet to see any court allow anyone to testify that wasn't a party to the matter, now that there's so many of these hearings going on. I'm not saying it can't happen, but I haven't seen it happen, okay? So you need to have some other people start trying to help as well. What else do you need to do immediately? You do immediately take a look and see, have you been ordered to surrender weapons? Because most of these orders will come with an order to surrender weapons, and there may be a second hearing you have to go to. You don't even know this. King County Superior Court has 2 hearings you have to do, one for surrendering weapons and one for the real hearing. Most courts do it at the same time, but there's stuff you got to do. You got to fill out paperwork. You got to say declaration of non-surrender. You've got to say I did surrender things. All this stuff you have to do, and you have to pay attention to it. It's a bunch of gobbledygook. It's like 30 pages, right? So you got to read it carefully. Also be looking for some legal help in that situation, because if you get it wrong, if you don't surrender weapons then you're supposed to, you could get charged with a felony, right? And then sometimes it's even gray. What if you don't have access to the weapon, right? What if the weapon that you've been thrown out of your house and it's at your home? You can't go in and get it because you're restrained from your home. Some courts say that's fine, do a declaration of non-surrender. Some courts say no, you have to call the police and they have to go with you to get the guns, right? How are you even supposed to know how to do that? So you need to take a look at that paperwork and see if you have to surrender weapons. Immediately, you also have to look for the law enforcement information sheet, right? There's a sheet that now you're supposed to fill out as the respondent, given all your personal details. This is my email. This is my address. This is my phone number. Here's my social media handles. It's pretty crazy what you're supposed to put down and file. So look for that. And they're also going to require you to file that as part of your case. And I think the final immediate action is closely read the temporary order to see where you're restrained from, right? You might be restrained from your own workplace. You might be restrained from their workplace, which is across the street. It might be 1,000 feet restriction. And you need to be careful, because this is an order. If it's actually a temporary order is issued, violation of the order is a crime, and it is a mandatory arrest under 1031-100. They find you violated it, they've got to arrest you and throw you in jail. And that's not something you want to see happen for potentially something you haven't even done, for something that you had no ability to even talk about in court. It's ex parte, one-sided. So the reason why I sound urgent is it is urgent, right? The consequences of these restraining order cases are severe. While they're not criminal, they're civil. They might as well be criminal, because the way it disrupts your life, the way it causes you stress, the way it can put a mark on you in some sensitive fields of work, not all of them, and how unfair it is. There's strategies that can be used to fight back, and we cover that in some other videos, but the strategies are evolving. Us people who represent the unfortunate people of the world that get on the respondent side of these, we're developing more strategies to make the situation more fair, despite how unfairly the legislature has set this up. So I hope this is helpful. If so, please like and please subscribe. More people get to see it when they need it. More importantly, if you got served with a restraining order, you can feel free to reach out to our firm. We got certain ways we do things. We get so many calls. There's some document reviews we can do, things like that. We're not guaranteeing we can help or represent you, but we help a lot of people with this area. We'll do our best to listen to what happened, identify a way forward, and we will be there for you. Thank you.